Morning, everyone, and thanks very much for joining us on this beautiful Tuesday morning. The topic of today's discussion is legal changes uncovered. So we're all aware that we know a lot of regulatory and legislative changes in the retirement funds industry of late, some already effective, some we can expect over the next year or so. So we took the opportunity just after the national budget speech to gather some great minds in the industry to delve into what exactly these changes are and what they mean for us as advisors, employers, and members. So a pleasure of hosting in today's panel, Head of Product at Discovery Employee Benefits, Guy Chennells, and Head of Legal at Discovery Employee Benefits, Nancy Andrews. Guy and Nancy, thanks very much for being with us today.
Thanks, Yash. Looking forward to the discussion.
Great. So we got a lot of content to cover. I see we have had record number of accepts for this webinar in the region of 1,000. 300 people have joined so far. We'll let the rest sort of trickle in as we go. But today we're going to be covering the conduct standard for late payment of contributions and the famous TwoPart system, which is set to go live next year. So we'll spend about maybe 10 to 15 minutes on the conduct standard, and then the rest of the session on the TwoPart system. Obviously, the Q&A box is open for everyone to drop their questions in case we don't have enough time to address those questions live, which we might address at the end of the session. What we said we'll do is we'll put together all those questions in a little PDF and develop the answers outside of the session and circulate that to all of the attendees of today's webinar. Standard for late payment of contributions. Let's start with Guy. I was at a session earlier today where this was raised. Can you just tell us briefly, like, what is it? What is the conduct standard for late payment of contributions?
Thanks, Yash. I'll give the non-legal, technical sounding version. So you'll get a sort of high-level picture, and Nancy can step in and correct me and give all the technical language afterwards. The way to understand it, I think in the simplest way, is that there's always been regulation around what should happen if an employee doesn't pay over their retirement fund contributions in good time being by the 7th of the following month. What this conduct standard does is it gives some teeth to that and some explicitness to what must happen if contributions are not paid over. And so many of you would know, I think, that if you have a retirement fund, someone needs to be the key individual, someone who's responsible ultimately for those contributions coming across. And the consequences for that person are specified and heightened under the conduct standards, along with, separately actually, there was a notice from the regulator to say that they will be naming and shaming employers who have contravened this regulation. So maybe just one or two more kind of clarifications on what the teeth are. Firstly, the conduct standard specifies what the interest rate is that you must charge, and it makes an important change. It says that you must charge that interest rate from the 1st of the month. Let's say you talking about contributions for January. You need to pay them over by the 7th of February. If you don't, interest will be calculated from the 1st of February. And that rate will be at prime plus 2. So it specifies the rate. It then specifies what the administrator has a responsibility to do in alerting the principal officer. The principal officer has to, within certain days, alert the Board of Trustees, and the Board of Trustees, within a certain period, has to alert both the regulator and the South African Police Service. And so that key individual could face very serious consequences if they continue to ignore requests to pay over that contribution. The one other thing it specifies is what information needs to accompany that payment. So what information needs to be in the schedule initially, what do we need to know about each member, and then what information needs to be given on a monthly basis, particularly if anything has changed within that. Okay. Yeah, I think that's the sort of 50,000-foot view.
Okay, no, that's very clear. And I guess you mentioned prime plus 2. in the current interest rate environment, that could be, quite high. Let's switch over to Nancy to give us a little bit more context into, I guess, why this conduct standard was implemented, and maybe just a little bit of color on what it means practically on a month-to-month basis for employers and advisors.
Yeah, thanks, Yash. I mean, as Guy said, I mean, nothing's changed. I mean, the actual legislation that governed the retirement fund contributions and payment of retirement fund contributions is still in place. What changed was all the additional consequential stuff that needed to be supported the legislation. So the conduct standard replaced Regulation 33, and it created a lot more avenues, a lot more requirements that administrators of funds have to actually get right up front. The big question is why this change came about. As you know, the FBCA is a supervisory authority. So we've seen over time that they've changed the PPRs for the insurance industry so that they can collect information on members, so they can, and on a group risk scheme to deal directly with members. And I think that this is the aim of this particular piece of legislation, is that collecting that information directly from about members from the employer allows the fund or the appointed administrator to deal directly with members, particularly because the conduit was always the employer to actually get across any kind of information. So it's of no use actually sending an employer a notice to a member telling the member that your employer hasn't paid the contributions. The employer is never actually going to send that through. So in this way, the obligation is now actually placed on the fund administrators to actually deal directly with members in those instances, so they're not prejudiced. I mean, from a trustee perspective, that's extremely important because they have a fiduciary duty to their members, so that they act in the best interest of the members. So I think that in some ways, this is progression in the industry in order for funds to be able to deal directly with members.
And it's good, if I can just jump in there, it's helpful actually as an industry to be told what you have to do, because sometimes things are awkward. A client's not paying and they're telling you this and that. And now you are forced under the legislation, the trustees have to send out communication to every member. That's the one I forgot, after a certain period of time, to say your contributions haven't been paid over. And that, of course, could be very inflammatory for the relations between the employer and the employee. But of course, it is also really important. Those people have had deductions coming off their pay slips and it hasn't gone across, so they need to know. And now as administrators, it's not our decision, gosh, we're wanting to name and shame a client, which of course we never want to do. That's our sort of primary kind of first up client, but we are forced to do that. So it makes the kind of playing field very clear for everybody. This is what has to happen and will happen, if you don't pay over contributions.
Right. No, I mean, thanks. It sounds quite positive, like a positive direction in terms of the streamlining of information and the flow of that information. I guess let's play devil's advocate. Is there anything negative? I mean, when I think back to the start of COVID, Guy, and Nancy, we were putting in place some measures to improve the affordability of retirement contributions. And now it seems like, the payment of contributions is going to follow a lot more rigid and strict process. Will there still be room for alternative solutions in the event of affordability?
I think there definitely will be. I mean, every fund is governed by a set of rules. Your rules determine what you can and can't do. And affordability is a big issue post-COVID, as much as it was during the COVID period. I mean, employers have not recovered fully. So there is a struggle sometimes to actually get contributions, but there's options available in terms of their rules, what they can and can't do. They need to actually look at their rules to make sure that they can actually use all those avenues created, as opposed to just not paying contributions. Because when you just not pay contributions, then it ends up in late payment interest that the employer owes. It also then kind of moves towards the situation where you're going to have liquidators being appointed. And then at the end of the day, ultimately, the benefit of members are being prejudiced by the fact that you have these additional steps which come at a cost and are reducing member credits in the fund. So I think that employers, and it doesn't help for employers to actually stop in one fund and then start or one umbrella fund if they participated and start a new one because they can't afford the arrear contributions in the fund they are. There's options to make payment plans with the trustees of the fund. So they need to exhaust those options before they actually kind of make big decisions.
And I think what's really clear, and maybe, advisors in this space could be clearer with employers, and maybe you can understand why not, because most employers will just pay always, but every employer needs to understand that they cannot use contribution deducted from pay slips, from pay for employees, for other things. It's off the table. The options that Nancy's talking about is if you have gone into trouble, you can sort of work out how to pay it back. That's fine. But if you're facing cash flow challenges, you need to engage with employees and perhaps go on a contribution holiday. But that needs to be agreed with employees upfront. You can't just, deduct from pay slips and not pay it over. That will get you into trouble. It will build up a debt that you have to service.
No, that's brilliant. I think what I'm getting essentially is what might be perceived as more a strict, stringent approach to payment of contributions. Actually, the ethos of it is more a collaborative approach between administrators, employers, and members, ultimately in the best interest of members.
Absolutely. The one thing, Yash, is we saw late 2022, there were directors of employers that were actually arrested for non-payment of contributions. We always have this idea, there's penalties involved, it's a criminal offense, it's a 10 million rand penalty, or both, or whatever the case, but we never ever saw it come to fore. But we've seen cases now that this is becoming more and more prevalent in the industry, and particularly because just as trustees are responsible for the retirement outcomes of members, the FECA is responsible on a larger spectrum to actually make sure that the trustees are doing their jobs. And that is actually still serving the needs of members who are members of their retirement funds.
Brilliant. Guy, anything else to add on that front?
No, I think that's good, hey?
Okay. So
maybe the last thing, we didn't actually say this explicitly, but that became effective the 20th of February 2023, 8 days ago.
Right.
So that is in play. So there's no sort of preparation for that. That's happening right now. Yeah.
Brilliant. So let's move on to the famous two-part system, or three parts, or how many parts is it? This is the big debate. Before we dive into what it is exactly, I think we've got some nice things to show around what it is exactly, and finally lay to rest how many parts it is and exactly what happens on retirement, retrenchment, withdrawal. What are the tax dynamics? It can get quite confusing because a couple of years ago we had the T-Day implementation, which created vested and non-vested benefits. Now those form one part, and now there's an extra two parts. We've got a nice little flow diagram to clarify the whole system. Before we dive into that, maybe Guy, let's start with a brief history, if you can, of the retirement savings industry in South Africa. And I guess the two-part is meant to address some of the challenges, but how have we evolved to a point where retirement funding is, in inverted commas, a crisis in South Africa?
Yeah, I'll do that at a very high level so as not to take up time. We're going to need to cover a lot, but basically, South Africa some decades ago moved from there you go, I just dropped in my employer name just to make sure it's in there. Subversive marketing. South Africa moved from a defined benefit to a defined contribution. Essentially, what that does is it moves the investment risk from the employer to the employee, and much of the decision risk around that. And what's happened since then, there's been a growing awareness as the kind of generations retiring have relied more and more on defined contribution, that the generation, that the sort of DC, defined contribution retiree population is hopelessly underfunded. So it's quite a wave, from a world where everybody would have received reasonable funding if they'd worked for a large employer that had a defined benefit fund, would have received a kind of reasonable pension. to a world where the vast majority, there's not just isolated sad incidents, the vast majority of people are retiring into a real unmitigated financial disaster. And so as that awareness has grown, there's been sort of a galvanizing realization that we need to do something about it. Treasury's been trying to drive the policies that would support defined contribution working better to protect the actual purpose of getting people to decent retirement outcomes. But that's been very difficult to do. It's always been the case that a lack of preservation, cashing out your funds along the way, is the main culprit of people not getting to decent outcomes. Fees contributes to it. So if you're in an environment somewhere where it's not competitive, that's a problem. People not contributing sufficiently is a small problem. It's education, but all of those are actually second order. The primary impact, the primary kind of culprit is people not preserving, but that has been the most difficult one to solve. So because we're in a country where people don't have sufficient social security net if they lose their jobs, and so it's very hard to say blanket across the board that you can't cash out your savings when you really need it if you don't have your job. So that's sort of been left to later as Treasury has worked on implementing other legislation along the track, and finally it's come to the point where they're dealing with the elephant in the room, which is trying to get people to preserve, and they're doing that by introducing a compromise. And the two-part system is the compromise that allows them to vastly improve on the preservation strictures while being cognizant of the legitimate concerns that many kind of stakeholder groups in South Africa have around that.
Nancy, anything to add on that before we dive into the technical details?
Not too much, but I mean, if you've been as long as I have in this industry, this has been on the cards way back when. I mean, it came out 2011, 2012, where we knew, if at that point in time, everything that on everyone's lips were T-Day and P-Day. So the P-Day was the preservation day. I mean, it's just come home to roost right now. Luckily enough for us, it's come with a slight twist that you could actually access your benefits, while still being employed. But what we have seen through through the time is that the main policy of Treasury wanting to actually align all retirement funds within South Africa, whether it's pension, provident, retirement annuities, preservation funds, we've seen that come to light. And I mean, with this two-part system now, they've extended it across into the retail space as well. So it's just come sooner than we expected. And I think that is largely due because COVID has kind of interrupted their relaxation on it for Treasury, because it was on the cards. It stayed quiet for a while. We saw Unitisation come out. We were hoping another 5 years before preservation, but I mean, then COVID hit, and then the next minute we know there's preservation with a twist.
And the dynamics of COVID, just to add to that, is at COVID suddenly everyone realized there are times when people need access to their money while they're still formally employed. A lot of people were employed without income or with much lower incomes, etc. And so there was this bill proposed to allow one to borrow against your pension fund when you're in financial straits. Of course, that can never work because you have to borrow under the National Credit Act, which requires you to have proof of income sufficient to pay back the loan. So that can never work. So that was subsumed, but it added sort of fuel to the fire, added urgency to the need to resolve this conundrum.
Okay. Before we get into, I think, so great, Guy and Nancy, given the objective facts and the history, I also want to discuss your views, whether you think it's good or bad. But before we get to that, let's cover what it is, because you mentioned preservation and Unitisation. It can get very confusing. So Guy, maybe do you want to just explain to us exactly what it is?
Yeah, I'm going to do that using some slides. This is the only part in this webinar where we'll use slides. But it is helpful because you can get quite lost, which I suppose is actually an indication of just one of the underlying points, which we'll make later, which is this world is becoming very complicated. So to describe the two-part system, what it is, it's helpful to first, as you mentioned earlier, Yash, to contemplate properly what has happened in the recent past. What happened in March 2021 is we created two concepts: the concept of a vested benefit, which is all the money that a person has accumulated up until that date, the 1st of March 2021, in a provident fund. Provident funds, of course, allowing you to cash out at retirement. And the vested there means you can still cash it out at retirement, even though we're changing the rules going forward. The amount you built up that would have been cashable remains cashable at retirement. Everything else after that goes into your non-vested benefits, which is treated the same between our pension and provident. So if you were in a pension beforehand, all of your money was only 1/3 cashable at retirement. Now, for people who were in provident funds, they join the pension fund crowd on their new contributions from the 1st of March 2021. Everybody's new contributions after March 2021 is treated as a pension type contribution, subject to annuitization. 1/3 of it must be annuitized, with a caveat. The caveat, of course, nothing can ever be simple. The caveat is that people who were 55 and older at the time, 1st of March 2021, they have a little sort of dispensation that allows them to continue to contribute to their vested benefits over that period. So their vested benefits apply to all of their money, past money and future money, if you were older than 55 on T-Day. Now, all of this is called the vested pot. When we talk about two pots, we're thinking about everything under this old regime and then everything under a new regime. So the new regime is now called the two-pot system. And the two-pot system has a retirement pot and a savings pot. And that's why some people are calling it the three-pot system, because you've actually got a vested pot, which has vested and non-vested, and a retirement pot and a savings pot. And you'll see why you would call that 3 pots rather than 4 in a moment. So the retirement pot requires you to annuitize that entire amount. So essentially what you've done, if you sort of see what's happening here, is it takes the non-vested type benefits, the pension type benefits, which would have been 1/3 and 2/3, 1/3 cashable, 2/3 annuitized at retirement, and it splits them out all the way up to retirement. So it says the moment you put it into a fund, 1/3 of it's cashable, 2/3 of it is only annuitizable. So then you're building up all of the time a 1/3 pot, which is cashable, not just at retirement, but even before retirement. And what in the draft legislation, what's currently proposed is that there's a minimum of 2,000 Rand on what you can withdraw. And you can do that once during any 12-month period. And that withdrawal, that kind of minimum is before taxes. Anything you withdraw is taxed as income tax in your hands, taxed as at your marginal income tax rate. So significant extra complexity added into this world. I hope that's reasonably understandable. To kind of zero home the point, I'm going to look at what happens then for someone at retirement and what happens for someone if they leave an employer and need to access some money. So at retirement, you have these kind of 3 worlds, or these 3 pots. You have your vested pot, which consists of your vested benefits. These are cashable. You can cash it out at retirement. And your non-vested benefits, 1/3 can be withdrawn as cash, 2/3 must be used to purchase an annuity. So these are this is your kind of old rules. And then when you get to retirement, you will also have a retirement pot. All of that must be annuitized. I'll touch on the de minimis rules in a moment. And a savings pot, whatever's left in your savings pot, if you haven't cashed it out en route to retirement, that can be withdrawn as cash. And what's been clarified recently is that will be taxed according to the retirement lump sum tax table. This de minimis, there's always been a de minimis on the amount. When you get to retirement, however your kind of pension and provident amounts are made up, the amount that you have to annuitize is subject to a de minimis rule, which says that if you have less than a certain amount, you actually can still just take that all in cash. It'll be taxed, but you can take it all in cash because it's kind of too small to try and eke out an income out of it. It's inefficient. Clarity is that the de minimis for your amount from any provider will apply to all of your annuitizable and annuitizing amounts. So it'll apply to the 2/3 from your non-vested benefits and your kind of old regime money, plus your retirement pot. So all of that will be subject to the de minimis rule. Then the question is what happens on resignation, termination, or retrenchment. So firstly, your vested pot, this is really important for people to understand. The vested pot, which at the day that we cross over, let's say it is 1st of March 2024, will be all of your retirement money. The vested pot can still be withdrawn. So your kind of cashable at retirement, your 1/3, 2/3 at retirement, those vested, non-vested pots in your kind of overall vested pot, all of that can still be cashed out as you could prior to this two-pot system. So all of those rights are retained as we move over into the two-pot system. Your retirement pot will not be able to be accessed. So that's the real difference for a person who's withdrawing under the new two-pot system. The amount that you built up into your retirement pot, you will not be able to access. And of course, your savings pot, you can withdraw. You can withdraw that once a year. Just kind of a clarification, if a member does want to not cash out any money, move their money to another provider, all of the pots need to be transferred to the new fund. And members, as they can today, can remain paid up in the fund, and the same exit rules per pot will apply if at some point you want to exit from the fund. On death, all of those 3 pots become payable to a member's beneficiaries as per the Section 37C section of the Pension Funds Act, which specifies how they should be distributed amongst your beneficiaries. So that, I hope, it was a bit of a whirlwind tour, but I hope that that gives just some clarity of what the two-pot system is. So as we go into some of the ins and outs, it'll be clear to everybody what we're talking about.
I think that's brilliant. And as we were in the session just before we opened the webinar, you were discussing what we could do as just that little section of your explanation. We just create a little video of that. We'll make that available. Because I think even after like a brilliant explanation like that, you sometimes just need a reminder, whether it's in the form of a 5-minute video or even some cue cards, that will go a long way in terms of helping people, advisors, our members, employers, just get to grips with what actually is happening and, what it means for the future.
Yep.
Nancy, we had a recent budget speech. And I know you mentioned, COVID sort of accelerated the implementation of the two-pot system, but it's also been delayed in a sense that the original plan was for it to go, which now it's been pushed out, to next year. Can you give us a little bit of clarity in terms of why, what is the underlying reason for the delays, and did the budget speech, if any of those reasons were to be addressed in the budget speech, were they addressed? What clarity came out of that speech?
So yes, the answer is basically twofold. Firstly, it was, yes, the promulgation date for this legislation was 1 March 2023. But during the consultation process for Treasury last year, this wasn't working. There were lots of things that were still remaining unresolved, and we needed to do this. The biggest issue was that the aim of this piece of legislation is to address the needs of low-income earners. And if the intention was to only take your contributions post the implementation date and put it into the savings pot, by the time those members actually build up in that savings pot, will be a long time. So there was a lot of struggle with Labour on this particulars, and Labour is one of our biggest stakeholders in the retirement fund industry. So Treasury went back to the drawing board. And what they actually kind of, through consultation processes, started talking about is the seed capital funding. So which is a start-off base in your savings pot. What happened is that the draft revenue laws amendment bill that was issued last year for public comment didn't make provision for this policy change. So they could never have rolled out the legislation without the policy being announced first, or without Treasury making an announcement of this policy in the budget. So the legislation as it stands only creates the avenue for the savings pot and the future contributions, 1/3 of your future contributions that are going to be put in that. In the budgets last week, I mean, the minister said this is going ahead on 1 March 2024. For now, it's a two-phased approach. The first phase is basically what is currently in the revenue laws bill, which is your savings pot and your retirement pot. The new things they're introducing into the bill that we're going to have to look at going forward is going to be the seed capital funding. Our understanding from the seed capital funding through consultations with Treasury is they're looking at a 10% of your accumulated benefits in the fund, capped at a maximum of 25,000. So for DC funds, this is actually easily, and you're able to actually kind of calculate this. On a DB fund, it's a little more difficult. Okay, so the second stage of the budget was, we need to actually consult around DB funds because we actually haven't got this pegged down as yet. So that seed capital, even though they have the basis on which they want to actually use what the basis which they thinking would be an appropriate starting capital in your savings pot, they can't actually they still need to work out how they're going to do that for a DB fund. Then the third part of the hiccup in actually implementing was the legacy retirement annuity funds. I said to you earlier that, Treasury always wanted to align across all retirement funds, the same tax policies, the same tax principle, the same tax benefits. And we saw that, when they did the contribution deductions in 2016. So for legacy funds, if you kind of reduce any benefit in the fund, it's subject to a penalty in terms of, it's subject to penalties, which doesn't actually work because members are being prejudiced by the fact that this legislation is creating an ambit for them to access, but at the same time prejudicing them because they have to pay penalties. So for now, those three are the main items that they're working on. We should expect to see this new draft bill in around about July, and then we'd have time to comment. But what has been postponed to the second phase is this whole issue on retrenchments. So when you're retrenched, like Guy said, when you withdraw, you can have your access pot, you can have your your savings pot, your vested pot. You can take all of that, but you can't touch your retirement pot. And for those people that are retrenched, Treasury is looking at whether or not they can actually kind of dig into the retirement pot for a short period of time to help people move the bar or to bridge the gap between finding new employment. And that issue hasn't been resolved yet, because what they would like to do is for retirement funds to pay pensions out of the retirement pot for these retrenched members over a period of time. All retirement funds don't pay pensions. So there's a lot of work that still needs to happen. But come 1 March 2024, the rest of it is going ahead. So we just got to brace ourselves. The problem in the industry is we don't have the final legislation, and we don't know how to actually work. So we have to wait and see what comes up.
Okay, and so seed capital, nuances on retrenchment. What about, when Guy was presenting the slide, there was a nuance around over 55s for T-Day. Is there another sort of layer that we need to consider for people? 55?
Yeah, so for the over 55s in the current draft revenue laws amendment bill, the two-part system doesn't apply to them. And, through the commentary process, we actually say to Treasury, but people work longer nowadays. They live longer, they work longer. So they're not necessarily going to just retire, and they could actually experience some sort of hardship. And when we propose this, and why not extend it to people over 55? And they came back, and we're very happy to. But the minute you actually extend it to over 55, it's an opt-in provision, and you can't actually opt out again. So for a Provident Fund member who was 55 on 1 March 2021, to opt into this new two-part system to gain access while he's still employed, will then mean that the balance of his retirement pot is still going to be subject to a pension, where currently he could get everything now in cash. So it seems like a win, but at the same time, not all Provident Fund members would want that. And the issue is that if they're going to make a decision, it's going to be across the floor. I mean, if you remember with contributions, initially they said up to 1/3 of your contributions must go to your savings pot. In the next draft we saw, it was taken out. I mean, it says 1/3. So there's no there's no discretion how much you can put. There's no discretion if you want to go in. So they're making the rules plain and simple. So if that's the case, I mean, Provident Fund members are going to definitely be over 55 are going to be prejudiced.
Yeah, but that opt-in rule is complicated. I mean, to actually manage that practically. So yeah, we wait with bated breath to see what the next round of proposals is with regards to over 55s and how that interacts with the already slightly funny and not quite rational treatment of over 55s from the T-Day,
No.
Not how you would put it, Nats.
Not how I would put it, Guy. I think an important thing to remember is the policy behind this two-part system, or the intention or the fit for purpose of this two-part system, is not to actually address the needs of high income earners. This is to address the needs of low income earners. On the flip side, the high income earners who don't access will benefit from the tax incentives when they retire. This is to help low income earners, and because they're taxing it at marginal rates, there's a possibility that even if their tax rate is below that, the low income earners would get, on assessment, would get a rebate or whatever the case may be. But I think the main part of this whole discussion, it's not a use it or lose it principle that they're actually doing. They're hoping that, people that are very affluent, that earn a lot of money, will not use the system, so that they could actually benefit from these changes or the incentives that they're giving us.
Yeah.
I think we've already started to touch on, sort of the views, because what I'm hearing is, given the history of retirement funding, particularly in the DC context, the intention is good, but what has emerged is something that could be seen as quite complex and a lot of nuances that need to be deeply considered. What are your, what are your views? Is it overall good or bad or neither? What's the view?
Yeah. Can I start, Nance?
But Guy, yes, go ahead. I'm sure
My overall view, because I have an opinion for once. My overall view definitely is that it is good. You've heard people at a first hearing of it, it sounds like, gosh, everyone can take 1/3 of their money in cash, and so people will have less in retirement. And that's completely false based on our experience to date of behavior in retirement funds. Because what you find is that most people have taken 100% in cash, as they've had the temptation to do that through job changes. So forcing a cap on how much people can take of 1/3, but allowing them to take up to 1/3 at any time, even if you project on a worst case basis that everyone takes 1/3 all the way through to retirement, the amount of money in retirement pots is vastly bigger than it would be under the current behavior within the existing regime. The important caveat to that, of course, is that it's that that restriction and that ability applies only to new money. So still what people have built up to date is still vulnerable to entire cash outs And that will remain the bulk of what people have in their retirement funds for, a long time to come. So it's not going to change it overnight, but that, I'm afraid, is just how it has to be. If you start touching people's vested rights, then, you run the risk of a run on the bank, everybody resigning quickly to cash out, and it can be a real problem. So it's unfortunately the path you have to take, a slow path of moving into a new regime. It's also why it's so important to get the regime right, is that it takes you 30 years to fully transition into the new regime. Best you have the design right, So we do need to make sure we get this right, although there's urgency to get it going by the 1st of March, and that was reiterated in the budget. 1st of March, it's happening. It must be done right rather than rush. And if we have to push it to the 1st of March, 2025, I think that's still a great outcome. Better than sort of locking into something in 2024 that will be, take 30 years to unwind.
Nancy, your view?
I just wanted to ask if you've actually opened the tax textbook and have you tried to read it? Because if the reading of tax legislation is so difficult, can you imagine how difficult this implementation is going to be? So this is a mammoth task, but it's not a bad one. It's a good one because it actually kind of helps low-income earners, like I said. But at the end of the day, I think Treasury is on the right track in terms of creating incentives for those that actually don't actually withdraw from their savings pot by giving them better tax benefits at the end of the day when they retire. So yes, it's daunting. It's a mammoth task that we have to deal with. The complications are never ending in terms of what we need to do. But I think that at the end of the day, the intention is to serve the members of retirement funds, and we'd rather have them having a little bit of access to it than actually withdrawing their full benefits, and then funds are sitting in a non-financially stable position.
Right. Well, okay, you speak of mammoth task. Let's get into that a little bit more. So it's happening. There's no debate around that. Maybe there's debate around the date, guys. You mentioned, if it needs to be pushed out to get it right, we could do that. We could see that happening. But practically, what does it actually mean between now and the date of implementation? What is the impact on us, then the employers, in terms of processes, adaptation of documents, legal documents? What can we expect over the next year?
I think that, the industry has been burnt before. When we saw the divorce legislation, and we all saw the draft legislation, and we all started changing systems and actually doing a whole lot of things in rules to be able to actually pay divorces and all of those kind of things. I think the industry is fixated on actually seeing what the final legislation is going to look like. But I mean, we're running out of time. June, July, we'll see the next draft of it. September is a consultation process. October, it goes to Parliament. January is implementation. It becomes promulgated if everything goes there. And March, we give effect to it. I mean, there's no way we can do this by then if we don't actually have some solid features to work with. I mean, apart from that, I mean, you've got the FBCA that has to register all the rules, because you can't give effect to any of this without your rules being registered or your rules being adapted. I mean, there's over 1,700 funds in the industry. The last I checked, and I may be off with the figures, so forgive me for that. But I mean, having to register the rules for these funds, does the FEC have the capacity to do it? I don't know.
I mean, I love that, Nats, because it's, we often talk about in the industry how hard it is to change our systems and processes. I mean, this is big. This is the biggest we've had to do. Because it requires setting up to be able to engage with all members at all times and to pay out to all members at all times. You need to set up completely new processes, systems, etc. Apart from just the record keeping. The record keeping is complicated, but even the engagement processes is complicated. But here there's a natural kind of speed breaker or bottleneck, which is that, as you say, every single fund's rules in the entire market will have to be assessed and changed. All of those submissions will need to be made, and all of those will need to be processed. Of course, the FBCA is not set up to review every fund's rules in the industry, in a 2-month process or something.
I mean, Guy, to add to that, I mean, it has to be registered before the 1st of March, because come the 2nd of March, you're going to have a troop of members wanting to access this seed capital that's already that's going to have to be in their pot, that we have to be able to distribute to them or allow them to withdraw. So
very hard to do practically, and I think that's that gives me some optimism that there'll be an appreciation for just the practicalities of implementing such an enormous change, because it affects everybody, actually all the stakeholders in the industry. I wanted to pick up something that you just mentioned on that. You spoke about people rushing to get access to this. I don't quite know what to expect. I don't think everyone's going to rush on day one to try and access a third of their money, especially because especially for middle and higher income people, to get 10% transferred into the cashable portion, which is what's been bandied about up till now in kind of industry engagements that you've been part of. If 10% comes across, there's a cap, a rand cap of that of 25,000 rand. That actually for some people, is not enough for them to sort of drop everything and try and access that on the 2nd of March. But of course, there will be a number of people who will want to access that money quite quickly. What's maybe helpful to viewers to put that into context is that we just did a calculation on our own book. It might be different for different kind of overall books. But if you have 10% of your existing money as your seed capital, subject to a cap of 25,000 rand, because there's such a skew in retirement funds, many people with very small balances, and then a few people at the top carrying almost half of the assets with much larger balances, that 25,000 rand cap means that the 10% actually becomes closer to 5%. So the amount of assets in the industry that would be up for grabs on the 2nd of March is closer to 5% than 10%. And so that sort of lessens the fear and panic around liquidity risks, etc. That's less than what retirement funds get into their coffers as cash flows coming in from new contributions. So we're not overly worried about liquidity, etc. Even if you assume that most or all of people who can access that cashable amount do so quite quickly after the law is promulgated.
Okay, that's interesting. So yeah, because of that skew, it's more in the region of 5%. So assuming we get through all the practicalities and actually implement this on next year, that's actually the true risk in terms of withdrawable cash. And I guess we did those calcs on the discovery asset values, given the distribution across members and the contributions would be expected to then outweigh that amount within a year or even less. Maybe just to tilt a little bit towards Discovery, Guy. Discovery's model and value proposition through its boosts to assets and contributions work on behavioral change. We've proved them through the use of loss aversion to increase preservation rates. Do you see that model still being relevant once TwoPart gets implemented?
Yeah, doubly relevant. To your old pot, which will still be the bulk of everyone's retirement assets. Remember that. The old money that's treated in the old way is still the bulk of everyone's assets for the next 5 or 10 years at least, maybe 20. And that is still subject to that temptation to cash out when you change jobs. So holding people through that job change process is still incredibly important. And our boost, as you know, basically put Discovery's money alongside someone else's money, but say it's yours if you don't cash out. So it encourages people to sort of resist that temptation. That remains critical for the next decade. The cashable portion in the new TwoPart system, your savings pot, is then available at any point. You have temptation every day of the week to cash that out. So having an incentive around not doing that is then even more important than before. And then what's lovely is that our boosts are funded on shared value, which means that if someone's kind of, say, retirement pot now stays all the way to retirement, that's fantastic for us. It creates extra value that we can share with members. It makes staying through to retirement more rewarding with Discovery, even though some of that pot you now don't have control over. And so we think our boost program is more relevant than ever, and in fact more valuable and rewarding than ever under the two-part system. So we never saw it coming, but we're really pleased with the way that our kind of incentivized product design fits on top of the new two-part system.
Right, brilliant. Nancy, anything, and Guy, actually, anything else to note before? I think we've got about 9 minutes left, so we do have some time to delve into some of the questions, about 10 questions coming through in the Q&A box, but anything else, any other closing thoughts?
I think, Yash, for me, I think that members of retirement funds always live in fear. You know, they pay, the employer deducts this money and puts it into a vehicle, and it's managed for them, and they hope to get it out. And then when they hear things like two parts and annuitization and all of those kind of things, they get very scared. I think that, you know, the key to actually seeing this through is making sure that members of retirement funds are properly educated around this, because I think that that's the lack, the lack of understanding and knowledge for members. It's what creates problems for them at the end of the day, because nobody's telling them what they need, what they need to know that is for their benefit, or people are telling them bits and pieces, and you know, the next minute everything's going to be in my retirement pot. So come 1 March 2024, we get a whole lot of resignations because they don't want that to happen, and everyone's wants their money out in cash. So I think educating members and that's a responsibility of trustees and the appointed administrators, is something that they need to focus on consistently over this next couple of months, and keep members informed right up to the point at which this becomes. Just one thing about the FBCA, we have seen them actually pull it out of the bag for us when we had the annuitization rules that come that had to be registered by 1 March 2021. So yes, it is going to be a mammoth task for them, but I mean, I have no doubt that they'll pull out the stops to get it done if they have to.
Yes. I think that's great. I think this webinar has really given a good feel for what to expect, how we can view the two-part system, and as well as the late payment of contributions conduct standard. Thanks, Guy and Nancy, giving us incredible insight into what's going on in our industry. I'll start with a few questions. Maybe. Okay, well, one easy to answer question is, will this recording be available? We will be distributing the recording after the webinar, so you can rewatch and focusing on specific sections that you need clarity on. Maybe one technical detail I'm seeing here, maybe we didn't cover it in full detail, but how many times can you withdraw from your savings pot? I mean, we mentioned a rolling 12-month period. What are the exact mechanics there?
It's once every 12 months rolling.
Okay.
Yeah.
And Nancy, my understanding is no de minimis rules.
No de minimis rules. I mean, as long as your savings pot is in excess of 2,000 Rand, you'd be able to withdraw. But also you need to remember that if you make a withdrawal from your savings pot, and then you, in the same year, in the same 12-month period, you resign and you go somewhere else to another employer, that balance of the savings pot is not accessible to you. So you have to actually transfer that to your new employer. So you've got to be very careful, not be very careful. I mean, the nuances in respect of how this works, we have to see it clearly in the legislation so that we can communicate it widely and people are aware. And hence I go back to the communication on this issue is paramount to us actually having a successful rollout of the two-part system.
Another on tax, I think we did briefly cover this, but what is the taxation on withdrawing from the savings pot? Because this savings pot can essentially be seen as a discretionary type of investment that sits in the retirement fund space. So what are the tax on withdrawal and then at retirement?
Yes, so the way in which the way in which Treasury sees it is the withdrawal is income in your hands. So it's basically going to be taxed at your marginal rate. And then whatever the balance is in your savings pot at retirement date, they would, it was announced in the budget that they would actually apply the retirement lump sum tax tables to it. So you would, and that is, I mean, I don't think, I'm sure everyone knows that's now been increased to 550K once over your lifetime, and your withdrawal limits have been increased to 27,500 on each withdrawal.
Okay, that's great. Maybe just a quick, who determines the part that goes into the savings pot and the part that goes into the retirement pot? Maybe just a bit of clarity on that.
Yeah, so I think that was a big issue, because the way in which the legislation was initially drafted, it said you could actually contribute up to 1/3 of your contributions. That's done and dusted. It's a strict 1/3, 2/3 split going forward. So nobody determines anything. As a member of a retirement fund from 1 March 2024, you will have a savings pot and a retirement fund, and any contributions that come into the fund from that day will actually go 1/3, 2/3 splits. So there's no variables that were, that are going to be put in place. I mean, we thought we could actually have in your rules, you could have ranges within which people could actually contribute to the savings pot, particularly if you didn't want someone didn't want to access their money, But now it was cleared up in the comments document that it's 1/3 savings, 2/3 retirement on all contributions after 1 March 2024. So there's no discretion.
And I suppose because there's no tax benefit to not having the money in your 1/3 pot. If you don't plan on cashing it out, it's treated the same as your 2/3 when you get to retirement.
Yeah, I mean, at retirement, you always have the option of moving whatever the balance is in your savings pot to your retirement pot and then buying an annuity post your retirement. So there isn't any kind of disadvantage to that.
Yeah.
I guess let's do one last question. We'll address the rest after the webinar and distribute the answers. But Guy, you mentioned the assets at risk, and now you have an accessible part, but actually your API outweighs that at-risk part. What are your thoughts on having a different investment strategy? Is there a need for that at all? Will both parts be invested in similar ways?
Yeah, we see that as unnecessary complication for two reasons. One is the actual quantum of what can be withdrawn is within the ability of a fund, of most funds, certainly our fund, to manage within this cash flow. So to net that off against in an outflowing cash flow. And then the second is that most of our retirement assets are in relatively liquid instruments. And so even if there was there was an unusual spike in withdrawal requirements, you'd be able to manage that within the liquidity of the fund. Maybe the third reason is that there isn't a specified time period around which you need to pay out these monies. So if you get the request and there is some liquidity constraint or concern, you could give yourself a fairly wide SLA around paying it out that would protect you if you were concerned about this, particularly for funds, I think, that have some non-liquid assets. They would want to build in some protection in a scenario where there suddenly was an unexpected kind of run on the bank.
Brilliant. Guy and Nancy, thanks. It's been an absolute pleasure hosting yourselves in this webinar. To everyone on the call, if you have any follow-on questions, remember to email us at retirementfunds@discovery.co.za. We hope you've enjoyed this morning's session, and we look forward to hosting you in another webinar in the near future. Thanks a lot. Thanks, Guy and Nancy.
Thanks,
Thank
Yash.
you, Yash.
Thanks a lot. Bye.